Okay, welcome to the consumer panel of the Seventh Circuit ACB seminar. I'm a very lucky person, very lucky panel chair to have three esteemed, two sitting judges and a former bankruptcy judge. They've made my job a lot easier, and I thank them for the time and commitment that they have put in. To my left, in the Zoom screen to my left, from the Northern District of Illinois, is Judge Deborah L. Thorne, who was appointed on October 22nd of 2015. Judge Thorne is a fellow of the American College of Bankruptcy. Judge Thorne also sits on the Diversity Committee for of the ABI, and she's the president-elect of the National Conference of Bankruptcy Judges. Huge job, and you're taking the reins in 2 weeks, is that correct?
Well, I think that my tiara can sit aside for a while because fortunately for me, Judge Bailey is going to be president, but.
Okay, president-elect though, and you did have the very difficult job of chairing the education committee this year for the conference that didn't happen in San Diego because of COVID. So I'm sure there were a lot of challenges associated.
It's happening though. It's happening with Insolvency 2020. So tune in.
Wonderful, wonderful. So we can all catch that on Zoom. And I think in 2021, the conference is in Indianapolis, right?
That's right.
Very good. Prior to taking the bench, Judge Thorne was a partner at Barnes & Thornburg LLP in Chicago, representing creditors and other parties in insolvency and bankruptcy proceedings, and also served as a federal equity receiver in cases involving commodity fraud in the Northern District of Illinois. And I should probably step back. I didn't introduce myself. I'm Debbie Caruso with Rubin and Levin. I am a bankruptcy attorney. I'm a Chapter 7 panel trustee, and I am now a sub-Chapter 5 small business trustee. So under myself is from the Southern District, my home court. On the panel is Judge James Carr. Judge Carr was appointed to the court on January 2nd of 2013. And prior to taking the bench, Judge Carr was a partner at Baker & Daniels, which was then known as Faegre, Baker & Daniels, which is now known as Faegre, Brinker, Biddle, and Reith. Judge Carr practiced at Baker & Daniels from 1975 to 2012, and having been on the other side of him many times, he represented creditors and other parties in very complex insolvency and bankruptcy hearings. Many accolades and awards as a lawyer, including a fellow of the American College of Bankruptcy, best lawyers in America for at least 25 years, and named the top lawyer in Indianapolis many times. The past 4 years, Judge Carr has been presiding over the ITT Educational Services Chapter 7 case, the largest for-profit education Chapter 7 case that has been filed to date. I know a little something about this because I'm the trustee. Judge Carr has issued orders selling $75 million of real estate and personal property, issued orders in connection with the administration of a $140 million pension plan and benefit plan, where all the participants received 100% of their benefits and $32 million came back to the bankruptcy estate. Judge Carr also issued orders in settlements that has involved the forgiveness of private student loans of $800 million, offering quite a lot of relief to former ITT students. Catty corner for me.
You didn't say that I also graduated a lot of nurses.
Oh, I forgot about that. We did have that. That actually was amazing. We had a graduation for 300 nurses that were left in a position of non-status quo without diplomas, and we figured out a way for the nurses to get their diplomas and entered an order.
By court order.
Your court order. That was amazing. Thank you for reminding me. under me and catty corner to me, as everybody knows, Judge Eugene R. Wedoff. Judge Wedoff served as bankruptcy judge in the Northern District of Illinois from 1987 to 2015, and he was chief judge from 2002 to 2007. And time does not permit describing all of Judge Wedoff's amazing accomplishments, such as serving as the president for the NCBJ, president and chairman of the ABI Executive Committee, a fellow of the American Bankruptcy College, chair of the Advisory Committee on Bankruptcy Rules. And the ABI recognized the wonderful work that the judge has done in the consumer bankruptcy area by renaming the Chicago Consumer Bankruptcy Conference the Honorable Eugene R. Wedoff 7th Circuit Consumer Bankruptcy Conference. Since retiring from the bench, Judge Wedoff has been representing consumers pro bono and doing some wonderfully great work in that area. On October 12th, the judge will argue before the Supreme October 13th, I believe, right? I don't want to miss it. Well, don't listen to me. We'll argue before the Supreme Court in the appeal from the 7th Circuit decision of the case City of Chicago versus Fulton. And I believe Judge Thorne, one of your cases, the Shannon case, is consolidated with that appeal also.
Peak. And Mr. Peak is still in Chapter 13, fortunately.
So good luck to you, Gene, and that argument. So the other day when we were practicing our Zoom, I learned a talent that Gene has that I had no idea about. So as we were practicing, Gene was busy in his kitchen, and I was very hungry. So I was very intrigued by what you were doing. And as I was watching, you pulled 2 beautiful loaves of bread out of your oven. And I wanted to just jump out of my Zoom screen and grab a piece. So maybe next year we'll have a topic on cooking. So many talents. So anyhow, let's get started. Judge Thorne, if an individual debtor files a case the same year that a previous case was dismissed, will the stay terminate with respect to only the debtor or with respect to property of the bankruptcy estate?
Well, it depends where you are. Before I start, though, I would be remiss if I did not thank John Gibbons, who was my extern this summer, who is now a second-year law student at Vanderbilt, who helped me with the materials. And I have decided not to have a PowerPoint, so you might want to grab your code if you want to follow along. Section 362 does provide an automatic stay, as everybody knows, protecting the debtor, the debtor's property, and property of the estate. But in 2005, Congress was concerned about perceived abuses to the bankruptcy system by persons who file repeatedly. In response to this, they enacted Section 362C3A, which provides that if you have filed in the last year and now you're filing again, that the stay shall terminate, and this is what's key, with respect to the debtor on the 30th day after filing the later case. Now, the court can enter an order extending the stay after notice hearing and finding that the new case was filed in good faith. But the question really is, what is meant by with respect to the debtor? Does it mean that the stay is terminated only as to the debtor's property, or to the debtor's estate? And courts are split on this. There was a petition for cert that was filed on the Rose versus Select Portfolio Services case in the 5th Circuit, and which had adopted the majority view, which I'm going to describe in a minute. The previous circuit that had ruled on this was the 1st Circuit in Smith versus Maine Bureau of Revenue Services, which adopted the minority view. The petition for cert was denied, and so we're still left with a circuit split. And I'm going to describe at the very end of my remarks the problem that this has created for Chapter 7 trustees. And I don't know if Debbie has ever had a case like this, but at least there's a suggestion that this should be clarified. The majority view took the view that courts look at the plain meaning of the statute, which the Supreme Court has told us we're supposed to do, and that the automatic stay does not terminate with respect to property of the estate, because it just says with respect to the debtor. But, and if it had terminated, and Congress actually knows how to deal with termination of the stay. They've talked about it in a number of different places in the code. If you look at the next section of the code, section 362 C4A, Romanet I, it talks about the stay is terminate, or the stay has to be imposed if you have more than one filing. If you've had 2 filings in the last year, the debtor has to come in with a motion to impose the stay. And if it doesn't do that, there is no stay. The stay shall not go into effect. And so it's not talking about with respect to the debtor, but the stay shall not go into effect. So the majority looked also at the words in section 362 H1, which uses the language terminating the stay to terminate it with respect to personal property of the estate or of the debtor. Thus, the majority says Congress knew how to draft this. They didn't draft it in a way that extends it to property of the estate, so it's only terminated as to property of the debtor. The minority view is that this is a very confusing and ambiguous section, so we have to look at some other things. And I meant to mention at the beginning that even though there's only 2 circuits that are split, over 50 bankruptcy and district courts have addressed this issue. So it's an issue that comes up frequently. The minority view, which is the view that has been adopted generally in the 7th Circuit, says this is ambiguous, and so we have to look at what Congress actually intended. And because I only have a few minutes today, though, I want to tell you about 2 excellent analyses of the minority view. One is Judge Wedoff's case in Ray Daniel, and the other is in Ray Smith, which was the bankruptcy court case that was later affirmed by the 1st Circuit, and that was written by Judge Fagoni, who was one of my baby judge cohorts. And it has excellent analysis, and I know he told me how much he depended on the in Ray Daniel analysis, but let me tell you about that analysis. The minority view says that it's ambiguous, so they look at what was intended by BAP-CIPA. BAP-CIPA was aimed to correct perceived abuses of the bankruptcy system. The House report reflects this by stating that 362 C3A was meant to discourage bad faith repeat filings. Those people who file wanting to use the automatic stay rather than for valid reasons, which frankly, I don't understand why anybody else would file. I mean, generally you file because you want to have the automatic stay to accomplish something, but that is the way the House report reads. And so the minority view finds that the best way to look at 362 C3A is to terminate the entire stay, including that as to estate property, where most of the property would reside anyway, because generally once the debtor files, there's not that much that is not in the debtor's estate, at least at the time of filing. So the question that I wanted to raise today, which I think is interesting and which at least seeks congressional help, if not help from the courts, is what is the impact of section 362 C3A in a Chapter 7 case, because it applies there as well. So let's consider a hypothetical situation. Maybe a little bit outlandish, but it's hypothetical and I can take that license. A pro se individual files a Chapter 7 case, which is dismissed 21 days after filing because they forgot, they didn't understand they have to take the debtor education course, and that case it's gone. Nothing they can do about it. They were doing this pro se, but they get smart, so they file another one. And this time they take the course, but they didn't realize they have to file a motion to extend the automatic stay. And in this particular debtor's situation, the debtor's property is subject of a non-judicial foreclosure proceeding where the bank is owed $900,000 and the property is valued at $1.5 million, a surplus of nearly $600,000. And I said I had some license to...
The debtor's filed this pro se twice.
Right. And Debbie's hoping that she gets this case because look at what she's got there. But did the stay, which was not extended, cover property of the debtor, property of the estate, or just the debtor? Under the majority view, the Chapter 7 trustee would have an estate to administer. They would be able to look at that equity, the $600,000, and distribute it to the deserving unsecured creditors. But under the minority view, the stay is gone. And this situation is discussed by Judge Klein in the Central District of California in an interesting decision called In Re Thu Thi Dao, where Judge Klein extensively examines the termination of the stay under various portions of the Bankruptcy Code and raised the problem that this section presents in Chapter 7 and why the cases, both the majority and minority, really come out of Chapter 13 land, which they do. But there's an impact in Chapter 7 that we very rarely discuss. And my guess is Congress didn't really think that through when they enacted the section. So first he looked.
Can I stop you for a second?
Yes, you can.
The grammar of 362C3 is incredibly confusing to me. So I know you, but prior to that, we have the words that say that the stay with respect to any action taken with respect to a debt or a property securing such debt or with respect to a lease. So a couple things about that language confuses me. First off, using the word taken makes it sound like it's something that happened in the past,
Right.
not what's going to happen going forward. But then, is it suggesting, like in your hypothetical, that actions with respect to property securing the debt can go ahead without a stay?
Well, as I said, I think it's very confusing. And I think that's why the minority view has really glommed onto, and with some justification, to trying to figure out what the congressional intent was, which was to punish repeat filers who are deemed to be filing in bad faith.
Right.
But you're also, as you said, you're also punishing all the other creditors.
Well,
Correct.
wait a second, because there's a real answer to the problem of applying this in Chapter 7. Debbie, I'm sure you didn't mean to suggest that the estate went away because relief from the stay was effectively put into effect. No stay. The estate's still there, whether the stay's there or not. And what a Chapter 7 trustee could easily do if there's no automatic stay is move for a non-automatic stay. If you've got $600,000 or something like that, I think the trustee can find the resources to bring the proceeding to get a stay put into effect.
However, remember my hypothetical is in a non-judicial. They're standing on the courthouse steps tomorrow, going to sell this property. And in that case, the trustee, this is happening very quickly. The trustee hasn't even had a 341 meeting yet. Trustee may not even know they have the case. So the trustee is the party in interest who probably needs to come in and impose the stay or to extend the stay in this case, or to really extend the stay in this case. And that puts the trustee in a bit of a pickle. The trustee is going to have to say that, first of all, the trustee has to know that they should do this. But let's say that the trustee gets wind that they're standing on the courthouse steps and goes into court. The trustee is going to have to show that the debtor has a reasonable chance of a discharge. Which the debt, I mean, and the trustee is now in a conflict situation on that because the trustee has an obligation to object to the discharge if it shouldn't be issued, number one.
You're talking about reimposing the automatic stay. And what I'm suggesting is that the court has the inherent authority to issue an injunction that's separate from the automatic stay. And I can give you an example. I had a Chapter 11 case in which, with no objection, a debtor in possession financing order was put into effect where the loan was coming from an insider. And when the debtor failed to make payments, the insider was just delighted to say the automatic stay has automatically terminated, no basis for this case going forward with a Chapter 7 trustee. To which my response was, the automatic stay may not be there, but I can issue a non-automatic stay.
What if the property's been sold? Can you get it back for me?
I was trying to come up with the answer to that question in my mind, and my hunch is that if we could show that there was some kind of fraud that underlied what took place, that there would be the opportunity to do that.
I just think this puts the trustee in an untenable position. And although my illustration is rather extreme, it seems, and I should tell you, I'm sorry, I think they're putting new gutters in my house right now, so I'll try to go on mute. But it just doesn't fit the Chapter 7 situation, where the trustee doesn't know, the 341 meeting hasn't occurred, and the debtors listed the property on their schedules. So they've done all that stuff. I mean, if the debtor hadn't listed their property in the schedules, I think the trustee has a better chance, because the trustee is probably not abandoning it because it doesn't know it exists, and it would actually exist probably into perpetuity if it has been sort of hidden. And the trustee can then come back in, as you're suggesting. But it seems to me that there probably should be either cert should have been granted, or Congress should clarify this, because it just doesn't, I mean, Chapter 13, yes, there's a ton of repeat filing, and we know that, and we want to have, and the debtor wants this stuff to be in their estate. In Chapter 7, I mean, what is this debtor? I mean, the debtor's going to lose the property probably anyway. Does he care whether his trustee is able to administer the equity or not?
Well, I'm with you. I think Congress needs to take action, and I'm happy to say that the ABI's Commission on Consumer Bankruptcy has made a recommendation that this particular provision of BAP-CIPA be repealed. Get rid of it entirely. You can keep the restriction for someone who's filed twice within a year and had both cases dismissed, but this one serves no real purpose. As you know, I'm sure from presiding over a big Chapter 13 call, it's just automatic to ask for the extension. It's never opposed. The extension's always granted. So this is serving no purpose other than generating paperwork for debtors.
It was typical of a lot of what happened in BAP-CIPA. Let's go punish these people, and not, as Judge Carr suggested, not very articulately draft it. And so it leaves you with this real pickle. And I thought Judge Klein actually did a really good job of writing an opinion, which was why cert should have been granted.
Judge,
Although maybe it's like a Ginsburg dissent, they should send it to Congress. That maybe that would be the go fix this.
Judge Thorne, as you say, under the majority view, there's no stay just as to the debtor, but there is a stay with regard to property of the estate. But in the Chapter 13 scenario, at some point, when the plan is confirmed, this property is not going to be property of the estate any longer. Then what happens?
Well, I think that's a great segue into Judge Wedoff's discussion.
That's what I got to talk to you about.
On your plan.
Okay. I just wanted to make an announcement that the first code, if participants have not seen it, is 1121. Okay, so we're going to move on, and maybe we'll come back and have some more discussion with respect to this topic. But Judge Carr, talk to us about the unfettered discretion a bankruptcy judge has to approve or disapprove Chapter 13 plan modification after confirmation.
Yeah, it's interesting because we didn't necessarily plan it this way, but all three of the things we're going to talk about today sort of reflect on one another, and they deal with the general problem in consumer bankruptcy cases of what happens when things don't work out as they were anticipated. What happens when something goes wrong in the debtor's bankruptcy case. So in what Judge Thorne was talking about, what happens when the case gets dismissed and the debtor needs to refile, and the issue that I just was talking about is sort of part of what Judge Wedoff is going to talk about, which is what happens in a Chapter 13 case when an obligation arises during the period of time that the plan is being executed and payments are being made. What do you do with that post-petition obligation that wasn't anticipated? My topic is, what do you do if things have changed after you've confirmed a Chapter 13 plan? Is there a way to deal with that in a way other than dismissing the case and refiling? And that question takes me to the section of the Bankruptcy Code, section 1329, that I'm going to nominate for the strangest, most curious provision in the entire Bankruptcy Code. How's that? I'm going to suggest that this one, to me, is a head scratcher. I first spoke about this section at the National Chapter 13 Trustees Conference a year ago, and it started to intrigue me. To understand why I think this section is so strange, is so curious, you have to we're doing all of this based on the history of the debtor that preceded the case. I want to note, and once, as Judge Thorne did, I want to recognize my summer intern who helped draft all the materials that we have on this. In your materials, it's called Switching to Plan B, Modification of Confirmed Chapter 13 Plan. And I had some great work by my intern, and I commend it to you. One of the notions that sort of hover over all of Chapter 13 is, although we have this pretty cut and dried statutory prescription about how we're going to figure out what disposable income is, and as I said, this 6-month look back period, the Supreme Court has said, if that turns out not to be a real indicator of what the debtor's income and expenses are likely to be during the planned payment period, what we call the commitment period, then we ought to look at what really is happening. And that's a case called Hamilton versus Lanning. And it's just a very important case for all of Chapter 13, but it's going to reflect on Section 1329 and modification of confirmed plans. So how is that basic structure that I just described impacted by Section 1329, the section that governs modification of confirmed Chapter 13 plans? 1329 is viewed as an exception to the notion that the confirmation order, the order confirming the plan, has a high degree of finality and is afforded res judicata effect. So we have to look at that section to get over that. And it may not seem strange that a debtor could modify that basic structure and the finality provided by the confirmation order if there are negative unforeseen changes that occur to the debtor's financial or personal circumstances after confirmation. But what if I told you that the debtor could modify the confirmed plan at any time after confirmation without demonstrating any significant change in circumstances, that that's not a requirement to modify the plan? And then what if I told you that it's not just the debtor who can modify this confirmed Chapter 13 plan, but the trustee on behalf of creditors or any unsecured creditor, so that you have a structure where only the debtor is allowed to propose a plan, and yet theoretically, a moment after confirmation, a creditor can come in and move to modify the plan without demonstrating any change in circumstances. To me, that doesn't make much sense. And that comes about because in 1984, once again, when Congress thought debtors were getting away with things, they added to the statute the provision that not only debtors could modify their plans, but also creditors could move to modify the plans, even though they have no ability to propose a plan to begin. Now, what if I told you that when that kind of modification is proposed, there is no standard in the statute whatsoever to govern how a judge rules on that request for modification? There is no requirement. Most courts have determined there is no requirement that anybody coming in to move to modify the plan has to demonstrate that circumstances have changed. And there's nothing in the statute that tells the judge what he or she is supposed to think about, look at, or what the standard is for deciding whether to grant the motion or deny the motion.
I've got a
Go
question. So the Chapter 13 trustee comes in and says, debtor's aunt died and left him a car or left him money. I'm going to modify this plan because now he has more disposable income. What do you do?
What does the judge do?
Yeah.
Well, I believe this may be, I'm not sure whether there's any other section of the bankruptcy code that affords judges on its face any more discretion than this section does. I think that I would, and most judges would use concepts of fairness and common sense in deciding whether to grant or deny that kind of motion. But, pretty obviously, my sense of what fairness and common sense is quite a bit different than yours, Judge Thorne, or somebody out in Texas or California or Tennessee or Idaho or any place else. So much for uniform laws governing bankruptcy.
Can I make an argument to?
Go ahead. I like it, by the way. I like all the discretion, but go right ahead.
Well, what Judge Thorne just talked about was not really a matter of income. This is not the debtor's earnings. This is not interest on some investment. This is essentially a gift. And when someone receives a gift, that's not really what we're talking about in the whole realm of Chapter 13. It's an asset, to be sure, but Judge Carr, when you went through the beginning of what needed to be done to confirm a plan, there's the best interest test. Well, what does that look at? What would have happened if the case was liquidated in Chapter 7? Now, presuming that this behest came late enough after the case was filed, it never would have been administered in Chapter 7. And so the best interest test has no application whatever. Similarly, if we're looking at the income of the debtor, it doesn't cover this asset. So I would say there's no basis in the code for the trustee to be able to ask the debtor to pay more because the debtor got a non-income item.
What did the Seventh Circuit say when you said that to them? In the Powers case?
The Powers case is something that troubles my heart greatly. I'm actually taking a medical risk to talk about this with you. But what the Seventh Circuit said was that not only did the bankruptcy judge err in denying a trustee's motion to modify based on new information about the debtor's income, but that despite the fact that there was no problem with disposable income, as you just defined it, that was something that a judge had an absolute obligation to take into consideration. And then, despite the fact that the debtor had been in the case for 5 years and was entitled to a discharge having completed the payments, the Seventh Circuit retroactively ruled that all of the money that became due had the trustee's motion been granted, now had to be paid in the remaining time of the Chapter 13, which had already expired. So they put the debtor in an absolutely impossible situation. And I can tell you that but for the fact that the trustee gave the debtor a settlement proposal that was too good not to take, I certainly would have been petitioning for rehearing in bank.
One of the things I want to make sure I get to say before I run out of time is that since the materials were published, the 11th Circuit decided another case that bears on this, and the case is called Whaley, W-H-A-L-E-Y versus Guillen, G-U-I-L-L-E-N. There is no West citation for it because it was decided on August 25th. It's 2020 U.S. Appeal Lexus 26980. And as a result of that decision, we now have the 11th Circuit joining the 7th, 5th, and 1st, saying there is no requirement that the person who moves for modification of the Chapter 13 plan demonstrate that there's been any change in circumstances as a condition of moving for modification. Now only the 4th Circuit in the Arnold decision, which is in the materials, has that requirement, requires that the movement must demonstrate a change in circumstances as a condition of modifying the plan. I know I'm going to start running out of time here pretty quickly. I would just point out to folks.
2 minutes.
2 minutes. I want to point out to folks, take a look at how modification of plans is dealt with in the Chapter 11 context. With the general rule with respect to modification of plans in Chapter 11 is only the debtor can do it. However, there's a special rule, and the section is 1127, and the special rule is in 1127E. And it provides for modification of plans by individuals in Chapter 11, and it does allow for, in that case, either the debtor, the trustee, the United States trustee, or an unsecured creditor to move to modify. But to do that, of course, you have to go through all of the disclosure statement and voting steps that are required in confirmation. Interestingly, if you take a look, we just had a panel talking about subchapter V of Chapter 11. The modification provision there is in section 1193C, and only the debtor can seek modification of a confirmed plan, and the debtor must prove as a condition of modification that circumstances warrant the modification. So a takeaway from all of this is if you had a debtor who qualified for both subchapter V and Chapter 13, and you thought there was some chance, likelihood that the debtor's income was going to materially increase, you'd be better advised to put them in a sub V than to file a 13, because you're not going to then be subject to somebody second guessing and coming along down the road and increasing the amount of payments under the plan. I'm done.
Okay. Great plug for sub V trustees. Thank you, Judge. Okay. Okay, Judge Wedoff is going to discuss the disastrous state of affairs for debtors in the Seventh Circuit who incur post-petition claims in a Chapter 13.
And if this PowerPoint works, we'll be able to do that pretty easily. But what I wanted to say at the beginning is that this Fulton decision that I'll be arguing in the Supreme Court next month is one in which I was helped very much by my co-counsel, Kathy Stege, and the lawyers at Jenner and Block. And I want to let them know that I really very much appreciate it. But Fulton deals with pre-petition claims in Chapter 13. And the question is, does the debtor have an automatic right to get back property that a creditor has seized or wants to seize in a pre-petition claim? But what I'm talking about today is something different. We're talking about post-petition claims. And post-petition claims can cause real problems for a debtor. The problems arise mainly when the debtor has a claim brought against them that is unexpected. Medical expenses are an obvious one. The debtor gets taken to an emergency room, and even if it's a minor matter, it could be a huge expense. If it's not insured, the debtor is going to have a very difficult time paying that while they're in Chapter 13. What I'm most familiar with are fines and penalties, because the debtors who have gotten parking ticket and red light violation tickets in Chicago are very likely to run into those same problems again after they file their bankruptcy case. The fact is they don't have a garage. They need to park their car somewhere at a reasonable distance by their house. They park it in an illegal spot, or it's street cleaning day and maybe they don't see the sign that says it's street cleaning day. In any event, it's very easy to get traffic tickets in Chicago. The red light cameras are notorious. These sorts of things can be unexpected difficulties in Chapter 13. Curiously, there's much less problem for voluntarily incurred debt. For a couple reasons, I think. First of all, most of the time when I was doing Chapter 13 cases as a judge, debtors would come in under Section 364 and ask for the court to bless the new car loan or the new mortgage home equity loan that they wanted to take out. There'd generally be no objection. The trustee would make sure they'd be able to pay, and that would be approved. But more than that, if the lender knows that the debtor's in Chapter 13, they're certainly going to want to have a blessing by the court that they're going to be able to get that loan repaid while the debtor's in Chapter 13. So voluntary loans, not so big a problem. These involuntary ones can be a real problem. Now, what are the big problems? Well, it depends on which mode of collection is involved here. Oftentimes, a creditor will be seeking to get the claim paid through the Chapter 13 plan. And that's fine if the debtor's plan contributions are sufficient to pay that claim and pay all the other claims that must be paid in the Chapter 13. So domestic.
Or isn't the issue that if the debtor is going to pay it through the plan, it's going to reduce then the amount available to other creditors?
You bet it is, and I'll have a slide right on that. So good point. But the point I want to make is that even if you've got some cushion, say it was going to be a 50% payout on general unsecured claims, and some big post-petition claim comes in that the debtor wants to pay through the plan, modifying their plan to do it, by the way. Well, that's great, unless that claim takes more than the 50% that they were paying to the unsecured creditors. Once you get beyond that, then you'd be eating into the fees of the trustee or the fees of the debtor's attorney or domestic support obligation payments. And once you start doing that, then the plan becomes totally unfeasible and the case craters. But the other problem is, what if it's not sought to be paid through the plan? What if the creditor takes the position, I can just enforce this separately from the debtor's plan? And so the creditor tries to take the debtor's car, or the creditor tries to garnish the debtor's wages. Well, then what happens is that assets that the debtor needs, their wages, their car, to complete the plan, to earn a living, are lost. And once again, the Chapter 13 fails. Debtors usually don't have enough extra money. They're contributing all their disposable income to the plan. And so enforcing the post-petition claim against those supposedly free assets likely results in dismissal of the case. So let's look at both of those options for a creditor to go forward. First question, can the creditor, post-petition debtor, creditor now, get the claim paid through the plan? Well, the Seventh Circuit unambiguously says yes. And this is a case in which, again, I was representing the debtors on appeal, in re Steens. And what Steens says is that anything involving property of the estate that the debtor's handling while the case is pending, that generates the claim, that generates an administrative priority under 503B1A.
Well, Gene, what if on my plan as a Chapter 13 debtor, I say that property's not going to vest until discharge?
Well, I get these great questions. That's going to come up in just a second, I promise you. Okay. What the Seventh Circuit says is that these fines that come post-petition are just like the tort liability in this Redding Company versus Brown case that the Supreme Court decided before the bankruptcy code was enacted. And if it's an administrative claim, it gets priority, and priority claims have to be paid in full. And there's even a provision of the national plan that automatically provides for that. And I would expect local plan forms around the country all have the same provision. You've got to pay your administrative claims in full. But the question I have is whether the Seventh Circuit's analysis in the Steens 2 case is correct. We're talking about preserving the estate. How does paying claims of the debtor for traffic tickets preserve the estate? Well, the Redding Company doesn't really apply to this situation. In Chapter 11, if a post-petition claim isn't paid through the estate, it's likely not to be paid at all because some new owner will come into the assets. These post-petition expenses, if they're not administrative claims, won't be paid at all. And the other thing that the Redding Company case said was that you got to look at that Chapter 11 debtor running a business in competition with other businesses. And if they're allowed to not pay their fines and expenses, they're going to have a competitive advantage over all of their competitors. Now, in Chapter 13, neither of those two things happens. Unlike a Chapter 11 debtor, a Chapter 13 debtor is a human being who will emerge from Chapter 13 and be able to be charged with any liabilities that they incurred while the case was pending. Certainly, when the case is over, they'll have to do that. Relief from the automatic stay might let them do it sooner. But more than that, there's a section of the Bankruptcy Code 1305 that specifically deals with post-petition claims and provides for them to be treated like pre-petition claims against the estate. You file a claim under 501 and it gets adjudicated for allowance or disallowance under 502. The notion that all of these things are administrative claims pursued by filing a payment request basically writes 1305 out of the Bankruptcy Code. Anyway, there's very little that a Chapter 13 debtor can do to avoid the Steens approach. About the only way would be to not have it be property of the estate. Steens says if you're not dealing with property of the estate, then you're not generating an administrative claim. And the weird thing is, and this is what Judge Carr said just a minute ago, if the debtor's got enough money in the plan to pay the administrative claim, why sure, do that. That doesn't hurt the debtor at all. The debtor makes the same plan contributions and gets rid of the fines that would otherwise be due at the time the case is over. So Is it a bad thing to have this be an administrative claim? It all depends on the debtor's financial situation.
Well,
But-
and tied back to what we were talking about before, if you have that circumstance, then there's a lot of incentive for either creditors or the trustees to look to see whether there's more income and a reason to modify the plan to increase the payments so that they can get what they calculated to be their dividend before this administrative expense claim raised its ugly head.
And
But go ahead.
somebody raised a point with the CARES Act and now the ability to extend these plans out for 7 years. How does that affect on the analysis, Gene?
I don't think it affects it at all. As I said before, if there's a need for relief from the automatic stay and a basis for doing that, that would be something that the creditor could seek. Otherwise, if it's something that they can wait on, if it's a small amount that's generating interest as traffic fines in the city tend to, there's no particular reason why it needs to be done right away. But in any event,
The other thing, Deb, as you know, for you to use the CARES Act to extend the payment period, the plan had to have been confirmed before March 27, 2020. It's not an answer at all for a plan that's being confirmed after that time.
And have you seen many of those requests to confirm because of COVID? Or
I've seen a couple where they've asked to extend because of COVID, and I'm still seeing a lot of people who are only coming back part-time. So I think there'll be more.
Okay.
but let me,
Go on.
yeah, I bet I've got only 5 minutes left, and I'm going to have to talk really fast. So let's go to the second thing. Whether or not we're dealing with a claim that could be brought as an administrative claim in the Chapter 13, there's still a problem that creditors would like to be paid early. They wouldn't like to wait for 5 years or maybe even 7 years. They'd like to get it right now. And they could perhaps get a quick judgment by default, garnish the debtor's wages, attach an automobile, lots of things that they might be able to do. All of that depends on the automatic stay. Now, if the automatic stay applies, then there would be at least some limitation on post-collection activity unless the creditor got stay relief. And stay relief is not likely to be granted unless the property that the creditor would like to glom onto is declining in value. So if they're trying to put a lien on a house and the house is not declining in value, there's no particular reason why the stay can't remain in place. There's not likely to be many times a showing of a lack of adequate protection, and it's likely that the property is necessary to complete the plan. So there's a likelihood of protection for the debtor if the automatic stay applies. How do we have the automatic stay apply? Well, most of the provisions of the automatic stay only deal with pre-petition claims, but two do protect all property of the estate. Sub 3 of 362A prohibits exercise of control, acts to obtain possession of property, and sub 4 deals with acts to create or enforce any lien. So that can be a real help, but you have to have property of the estate. Chapter 13 defines property of the estate very broadly, everything that's in 541 and everything that the debtor acquires thereafter until the case is closed, dismissed, or converted. But there's 1327A. And what that says is all the property of the estate vests in the debtor when the plan is confirmed, unless the plan or the confirmation order provides otherwise. Vesting removes existing property from the estate, gives it to the debtor. Under 1327A, then, the debtor's property will lose protection from the automatic stay unless the plan or the order of confirmation delay that vesting in the debtor. And the Seventh Circuit has issued a couple of decisions that make it very difficult to keep the property in the estate. The first is the Steens decision, the Steens 1, this is, that says a confirmation order of a judge basically can't do it. It's an exercise of discretion by the bankruptcy judge, and it's an abuse of discretion to limit vesting without case-specific findings that continuing estate property is necessary. And here's the crazy thing. Keeping the stay in effect the court says in dicta, is not a sufficient reason to keep property in the estate. The Cherry case is the next one, and that deals with a plan that keeps property in the estate, delays vesting. And again, in Cherry, the Seventh Circuit says that the judge would have to make case-specific findings that that provision is necessary to confirm a plan that keeps it, and the Steen's dicta is repeated. Keeping the automatic stay in place is not a sufficient basis for retaining property of the estate. Now, that's crazy in several respects, I think. Number one, there's an express provision of the bankruptcy code that allows the debtor to provide for delayed vesting at any time later than confirmation. That was argued in the case before the Seventh Circuit, but without allowing oral argument and in a decision that does not even cite 1322b9, let alone discuss it, the court says that the plan can't do that without reasons. Next, the National Chapter 13 plan, which I mentioned earlier, has a specific provision allowing debtors to opt for delayed vesting. 1327b gives no discretion to the court to impose new requirements for confirmation that aren't in 1325A, and there's no such thing as a need for reasons to use the 1322b9 option of delaying vesting. And if there were a need for a reason, the only reason that a debtor would ever have for continuing property of the estate is to get the protection of the automatic stay, as the Keith London treatise indicates. So a post-petition creditor does not need, oh, and that's the other point. There's no need for this rule in Steens. The administrative claim possibility gives quite adequate protection for most debtors, most creditors, I should say, with post-petition claims. Now, what's going to happen? No other circuit has ruled that the fines and penalties incurred by a Chapter 13 debtor are administrative expenses. So other circuits may disagree. No circuit has ruled that 1327b requires findings and reasons for continuing property of the estate. That can also be challenged in other circuits. And finally, the dicta in the two Seventh Circuit cases that say that continuing the automatic stay is not a good reason for continuing the estate, that can be challenged in the Seventh Circuit itself because it was dicta. So what's going to happen? We'll have to see.
Sounds like it's your next case maybe, huh?
Yes, and I talked fast enough to come in before our period ended.
All three of my panelists, I really want to thank the judges. Thank you so much for the time and commitment. I have one last announcement, and that's with the second code for the participants, 3465. And we did it. We're on time. Thank you all very much. And everybody have a good weekend.